Good afternoon, everyone, and welcome to this week's webinar. Just as a friendly reminder, please don't forget that these webinars are intended for educational purposes only, and while we hope that you learn new information, the trainers that present these webinars are not attorneys. Therefore, all information provided during the presentation and during our Q&A session should not be construed as legal advice. All right, well, with that out of the way, good afternoon. My name is Brianna Grimes, and I am the Senior HR Services Advisor for Pay Entry, and I'm very excited to facilitate our webinar this week, talking about the top 10 FMLA mistakes that employers make and tips on how to avoid these mistakes. Remember that if you have any questions during the presentation, please feel free to type them into the question box, and they will be addressed during the Q&A session at the end of the webinar. With that being said, let's start talking about the top 10 FMLA mistakes that employers make. All right, so we're going to start with mistake number 1. Now, these are not in any preferential order. So they're not in the order of the most common or anything like that. What I've tried to do with the webinar today is I've tried to order these in the most logically progressive process of FMLA. So starting with an FMLA request, moving all the way to when an employee returns from FMLA. So just tried to really organize it that way so it's a little bit easier for y'all to follow. But this first mistake is going to be probably the broadest mistake that employers tend to make before we jump into mistakes going along that process. So the first mistake is that employers tend to fail to meet some of their basic obligations. Now, there are several basic requirements that employers overlook the most often when it comes to FMLA, and these are the most common ones that make up kind of this first major mistake. So the first requirement is posting updated FMLA posters each year or as they are updated by the federal government. Also developing and distributing an FMLA policy. Now you can distribute this policy via your employee handbook. That is the most common method, but having a clearly defined FMLA policy on hand and available for employees is a requirement. Also providing approvals, denials, and any form of designation notices to employees in writing. So not using that practice of, verbally approving or denying a leave of absence, getting that in writing is actually a requirement. Also following guidelines for tracking and processing FMLA requests appropriately, and absolutely no retaliation against employees for exercising their right by taking FMLA leave. So this, in terms of the most broad error that is commonly made amongst employers, these are the obligations that are the most commonly not met, and these are the ones that you should be meeting and or making adjustments in order to follow these rules as far as FMLA is concerned. All right, so mistake number 2 is not recognizing a leave request or a need for a leave. Now, there's not really a secret passphrase or a code word, that indicates an employee may need FMLA. And remember that FMLA is not limited only to medical emergencies. Any type of medical issue might be covered under FMLA. So employers are really obligated to identify the possible needs for FMLA and notify the employees of their rights to take FMLA. Now, note that the employee does not have to ask for FMLA outright, nor do they have to ask for information or even for a leave of absence for them to be eligible for FMLA. It's really the employer's responsibility to provide the employee with the information that they need and then let them choose if they would like to complete the application and certification process in order to utilize the leave that they have available to them. Now, the important question with this particular mistake is, what do employers need to look for that trigger an FMLA claim? Well, there's not really, a one-size-fits-all, but some examples of things that you and your manager should be trained to look for are things like regularly scheduled time off, either to visit a doctor or, do some physical therapy or anything like that. And this is basically any doctor's appointment outside of their annual physical exam. So if they're regularly scheduling time to visit a doctor, for whatever reason, they may need to be informed of their FMLA rights in order for them to take any time off or protect those leaves of absence that they have to take for these appointments. Another example is regularly used PTO or sick time for things like headaches or stomach aches or any medical issue that causes them to miss work. So employees that ask to leave early a lot or come in late due to a medical issue can also be kind of a trigger of something you need to look for to apply intermittent FMLA leave and notify employees of their FMLA rights. Another example might be frequent accommodation requests for specific tasks, or even absenteeism requests where they provide a lot of documentation. So if they're calling out a lot or they're missing a lot of work, but they have documentation, either they're taking care of a family member like a child, or they're taking care of their own personal medical issue, or they're requesting a lot of accommodations for some of their employment tasks because they're not able to complete the task due to a medical issue, those would all be triggers that they might possibly need some FMLA time. So if you have an employee, that fits into any of these categories, it'd be a really good idea to provide them with the policy and the documentation that they would need in order to apply for FMLA. So as far as action items go for this specific mistake, there are some things that you can do as an employer to make sure that you don't fall into this trap. So really it's important to know what is covered under FMLA so you can be sure to spot some of those possible triggers for FMLA claims. You also need to know if your state has state leave laws that coincide with FMLA and what they cover if they're different from FMLA. So this is really important in states like New York, California, I believe Massachusetts just passed a leave. So states like that have these state laws that run concurrently with FMLA or might be different to subsidize FMLA, it's really important that you be familiar with those so you can make sure you're letting employees know of all of the available resources that they have. And finally, it's also important to train your managers on what to look for so they know either to notify HR or to provide the FMLA information to the employee directly to fulfill the employer's obligation. Now, it is not recommended that managers directly handle their direct subordinates' FMLA leaves of absence because they will gain access to some level of personal medical information. So it's always recommended that you have one representative at the company who is not in charge of any form of hiring, firing, or promotion decisions for the employee to handle and process the FMLA leave, look over that certification, and handle that paperwork. However, if for whatever reason you have it structured that your managers are handling at least the communication bit where they are providing that initial information to the employees, the managers need to be trained on when to provide that information so they are helping you and your organization meet those obligations of informing the employees of their rights. All right, mistake number 3 is not including all the time worked when determining employee eligibility for FMLA. So remember here that an employee's actual work week is the basis for determining FMLA leave entitlement and eligibility. Also remember that one of the qualifiers for FMLA is that the employee had to have worked 1,250 hours during the last 12 months prior to the start of their leave. Additionally, things that may need to be factored into these hours are things like overtime or working lunches or even temporary work for the company during that 12-month period. So keep that in mind when you are calculating the eligibility for FMLA. Now, just as a quick reminder, when calculating FMLA leave entitlement, you will use 12 weeks of leave time that's available to them. 12 weeks of leave times the number of hours worked per week for that employee. Now, that formula works for the vast majority of employees, but not all of them. The question is often posed, what happens if my employees have a variable schedule? How do I calculate that? So if your employee has a variable schedule from week to week, you must take the weekly average of hours scheduled, not worked, hours scheduled for the last 12 months prior to their leave. And this method really allows a truer picture of the employee's actual average work week for the entitlement calculation. All right, mistake number 4 is requiring inflexible notice procedures for employees who might be eligible for FMLA and whose notice did not follow your necessarily regular attendance protocols that you have in place. So with this specific mistake, employers should really allow room for exceptions to their rules and caveats for flexibility. So these exceptions should really allow for employees to notify employers as soon as is practicable, which is actually what is written in the FMLA Act itself. And if it falls outside of your attendance policy requirements, again, this is where that flexibility would come into play. Now, these exceptions can be retroacted once the leave is approved, especially if any of the absences that this employee may have accumulated would have been grounds for discipline. So once the leave has been approved, if any of their absences recently was for the reason that was approved, you can retroact the approval dates in order to protect those dates to benefit the employee so they don't get put on a disciplinary action for what would be protected time because of the leave that you have approved. So really the question becomes, how do you determine when exceptions may apply? And this is really the struggle that a lot of employers run into. The things that you want to think about is start by asking the question, was the need for the leave foreseeable to a reasonable degree? So here's an example to kind of give you an idea of how to answer that question. So let's say we have an employee who has a major surgery scheduled 4 weeks from now. Well, the hospital staff calls her up and says that they can get her in for the surgery this upcoming Monday. She accepts the appointment and reports the new leave start date to her employer. Is this a situation that should be granted exception? The answer is yes. While the pre-scheduled surgery was foreseeable and this employee scheduled it appropriately with the employer, the new surgery date was not foreseeable, and the employee reported it to the employer as soon as she was able. Especially if it's dealing with a major surgery or an event that affects their overall quality of life or is preventative or even, a life and death situation in any way, a sooner surgery date is going to be a good thing for the employee. And the one thing I want you all to remember is that when we are being flexible, when we are making exceptions to the rule, we want to do what is best for our employees, even if it might inconvenience the organization. Now, a second thing to take into consideration is what are the facts and circumstances surrounding this particular FMLA claim? Did the employee provide the information as soon as reasonably possible? Is the employee dealing with outside factors that may have caused unforeseeable changes, especially when the leave pertains to taking care of a child or a spouse? Leaves of absence are one of the few topics in HR that really are handled on a case-by-case basis, and sometimes uniform policies are not always the best course of action because of the nature of the circumstance. Remember that we want to do what's best for the employee within the parameters of the law. So keep all of this in mind when you find yourself maybe being a little bit too stringent with your policies and practicing maybe things that are too inflexible, and allow for a little bit more flex. All right, so mistake number 5 is not giving employees a chance to provide their medical certification. Now, employers are required to allow 15 calendar days from the date of the request for employees to turn in their medical certification. And remember from mistake number 1, this notice has to be provided in writing in response to the employee's request for leave. So additionally, this notice should also state a few things. So it's going to state the exact due date for the medical certification, and you also want it to notate the consequences of failing to provide the certification. So if the employee does not provide the certification by the due date, nor do they request an extension, the leave of absence will have to be denied because you cannot approve the leave without the appropriate medical certification for the leave. Now, additionally, you as the employer should also be prepared to ask for clarification if the medical certification is not filled out completely, which happens a lot. So be prepared to call the healthcare provider and ask about, certain questions that maybe were left blank in order to get more clarity, so you can make an approval or a denial decision for that leave. Now, I'm not sure how many of you have ever used FMLA leave yourselves or worked with people who have had to take FMLA, but over my career, I've met a lot of physicians and talked to them about FMLA leave, and a lot of physicians and healthcare providers absolutely despise filling out medical certification forms. It's just kind of a common fact. And it's one of the most tedious things that they have to do. And most of the time, the reason it can be a little tedious is that the attending physician is the one who has to fill out this paperwork. It's not something that they can delegate to a nurse or a nurse practitioner or even the receptionist to fill out. Therefore, as a general rule of thumb, when it comes to medical certifications, if your employee is communicating with you regarding the status of their certification, even if they're asking for extensions, just be open to allowing and offering those extensions for the due date, and again, being flexible. Sometimes it is absolutely out of the control of the employee, and they're really waiting on the physician to have some sense of urgency to complete the documents because it isn't always a priority for the physician. Now, another thing to keep in mind that this has actually been an increased problem due to the COVID-19 pandemic, not only because of the influx of patients that healthcare providers are receiving, but also because of the limitations of the social distancing and the amount of appointments that they're permitted to have. It's also lowered their ability to meet different requirements and to fill out paperwork and provide doctor's notes and things like that. So they're working around a lot of different parameters right now. So just that ability to be flexible and really work with your employee can be very, very helpful in this process. All right, a little over halfway there now. We are on mistake number 6. So mistake number 6 is calculating the amount of FMLA used incorrectly. Now, I'm not going to go into too deep how to calculate the amount of FMLA used, because if you do have questions on that, or if you do need assistance on that, you can always reach out to Kathy or myself, and we can kind of talk you through that. But I do want to emphasize here that the main mistake in this calculation is that employers use the wrong increment to make this calculation. So how do you avoid this particular mistake? Well, you want to make sure that you use the smallest increment of time and actual days worked. This is the requirement by FMLA. You also want to allow employees to use FMLA in the smallest increment allowed for other leave, and this may vary from state to state as well. Also remember that you can exclude days that an employee would not be scheduled or expected to work from your calculation. You do not have to count those into the calculation. And examples of these types of days might be weekends, temporary closures, or holidays. So remember that you can exclude those from your FMLA calculation. All right, mistake number 7 is a big one, and it is very easily avoidable, but it also is one that increases a lot of employer liability. So making comments or any type of derogatory remarks regarding an employee's use of their leave is a huge mistake, and unfortunately, we see a lot of employers make this mistake. Now, realistically, the issue here is that these types of comments increase the employer liability because they become the basis of findings for intent to retaliate. And what that means is that it looks like there was an intent to retaliate from the employer to the employee, either during or after they return from their leave. And this is where the liability comes in because there's a lot of claims and cases out there for retaliation. And unfortunately, derogatory comments or any type of negative comments or snide comments that are made, especially if they are made in writing, so via email or your inter-office work chat, they just really don't help an organization's case in proving that there was no intent to retaliate. And it really seems like it should go without saying, but there are still some that are not able to curb their comments. And there's a lot of people that don't realize that if you send it in an email and you put it in a chat, whether it's a Teams chat or a WebEx chat or whatever system you use, they are able to dig it up. It is there forever. And it will be subpoenaed in the case of a legal claim. So just kind of keep that in mind. And the main action item here is really just to ensure that your managers keep their comments to themselves and train them to do so. And again, if your managers are going to be the main point of contact for FMLA claims for their team and be that first person that gives them information and reaches out, they really need to be taught what they can and cannot say, as well as what they can and cannot ask regarding the leave. These are very, very important things that increase the liability for employers. So one example might be if a manager has a relationship with an employee in terms of the employee is not a great performer and they're getting ready to take FMLA leave, we don't want the manager saying something like, you're on thin ice already, taking a leave of absence might cost you your job. Things like that are a big no-no, and a lot of managers don't necessarily see that that's not something appropriate to say in that moment. So this is where training and just constant reminders and walking them through this process really helps just to make sure that they understand that there is some legal liability here in this process in whatever role that they play. All right, mistake number 8 kind of ties into mistake number 7. It really piggybacks off it, but another form of retaliation is when managers treat employees differently before and after their leave of absence. Now, we're not necessarily talking about scheduling meetings or trainings to really bring that employee up to speed on what they missed while they were out, because that is part of the process. When they come back from leave, you want to make sure that they are up to par and that they know what happened, and you're going to have them sign documents, or if you rolled out a new handbook, you want them to read over the new handbook. That's totally acceptable once they come back from leave. What we're really talking about here is things like an employee being subjected to a stricter scrutiny after returning from their leave. And sometimes you see this when managers had to cover an employee's position or another manager's position, and maybe they weren't doing their job before leave to the expectation that they were supposed to, and now you're trying to hold them to a stricter standard. That is a big no-no. That is something you cannot do. So when an employee receives something like, a poor performance review, even though their reviews before were good, this all kind of triggers that there might be some retaliation going on. So you have to be very, very careful in terms of how you are handling an employee that returns if during their leave you discovered they weren't as great as an employee as you thought they were. Another example of this type of inappropriate treatment might be putting an employee on a corrective action when they return from leave for either attendance or performance issues that occurred before their leave. I always recommend some very, very tight discretion when you are making this decision. The main concern, especially with the attendance issue, is that some of the previous absences that may have caused the disciplinary action may have been protected under FMLA, given what you approved the FMLA leave for. So they should have been protected once the employer was made aware of the issue. And if it's a simple documentation error where your organization did not document that those dates were protected, and they really were, and now you put this person on a corrective action, you've got a retaliation claim waiting to happen. So I always recommend exercising caution with any type of corrective action for pre-leave incidents being delivered for a post-leave return. More than likely, if an employee was not a great employee prior to their leave, after their leave, unless their performance was suffering due to whatever issue they had to go on leave to take care of, when they come back, they're probably still not going to be a great employee. They're still going to have attendance issues. They're still going to have performance issues. And at that point, you can kind of take it from the end of the leave and move forward and document any future incidences as they happen. And if they're not a good fit for your organization, if they're not performing, then you can handle those disciplinary actions according to your progressive system. But I don't recommend, in most cases, to try to write someone up or put them on a corrective action as soon as they get back from leave for something that happened, upwards of 12 weeks ago. All right, mistake number 9 is failing to adjust goals and expectations accordingly. So when an employee returns from leave, you still have the ability to treat them like any other employee and hold them accountable to their position, their job expectations. The only exception is where there was any type of accommodation that has been requested. So remember, when someone comes back from a leave of absence, sometimes the medical provider or even the the employee will request some type of accommodation. Maybe they need reduced hours, maybe they can't lift, they can't stand for a period of time, depending on what they're still recovering from the medical spectrum. So that would be the only exception to this. But other than that, you can pretty much hold them accountable and treat them the exact same as before they left. Now, the one thing to keep in mind with that is that employers should reasonably make the effort to adjust goals and expectations downwards to account for the leave period. Otherwise, you really risk an FMLA retaliation claim being filed, and that's what we want to avoid doing. So this really includes anything that runs the gambit of KPIs, sales goals, performance metrics, SMART goals, anything that you use to measure employee success or that could result in any type of disciplinary action will really need to be adjusted accordingly before the accountability piece gets put into practice. So if you have a sales employee go out on leave and you're still holding them to that same quarterly sales metric and they were out for 2 of the 3 months of the quarter, that's not fair. That's retaliation in a sense, because you're trying to make them accountable for something that they they can't achieve because they were out for 2 months. So just kind of keep that in mind and make sure you're making those adjustments when employees come back from their leave. All right, and finally, mistake number 10 is when employers assume abuse of leave instead of investigating it in a careful manner. So we see this the most often with intermittent leave. We also see it with consecutive leaves on occasion, but it's most often with intermittent leave. In fact, a recent poll indicated that 65% of companies stated that intermittent FMLA leave was taken unpredictably, meaning that it varied from the certification that was approved. However, we have to avoid the assumption that every deviation from the original approval is abuse. Physicians are not psychics. They can't look into a crystal ball and tell you exactly how often an employee is going to miss work due to their medical issue. They can only guess, and the information that they provide you is really an estimate or a guideline in order for you to kind of have an idea of how often this employee is going to be out of the office. And we really have to keep that in mind and treat it as such. It is a recommendation. Now, overall, you really want to tread carefully with this topic. And if you do think that there is abuse going on, you must carefully investigate it or even hire someone to assist you in further investigating the possible leave abuse, because this can be a very touchy subject in the sense that past precedent and previous court cases have gone both ways, and it is really dependent on how the situation is handled. And there's really not a flat precedent across the board. So I would highly recommend, rather than investigating it yourself, if you've never done it before, hire someone outside. You can ask Kathy and I for assistance, or you can get an employment attorney if you feel that there is a need to do so, to really look into this for you, because you don't want to increase your liability by doing something wrong that you don't necessarily know what you're doing wrong. Now, there are things that you can do to avoid employee leave abuse, and that's ultimately what we want to do. We want to be proactive and avoid it altogether. So we can start by getting a completed medical certification. And this is kind of going back to what we talked to in, I believe, mistake number 1 or 2. Make sure that you are prepared to clarify anything that is not detailed on the certification, so you can get a very clear idea of exactly how much time this employee is going to miss, and kind of what that time is for, because that should be stated on the medical certification. So there's a difference for intermittent leave if someone is going to be missing time for, let's say, a physical therapy session that should be scheduled, every Wednesday at 2 o'clock, or someone who might be missing time for migraines. Migraines aren't going to be planned. The physical therapy sessions are. So kind of take that into consideration when you are reading over the certification that you receive. If it's not detailed, if it's not clear, feel free to call that healthcare provider and ask for clarifications. And this is something that you should really get comfortable with asking for, is clarifications on anything that is too vague. Just remember, like I said, you are permitted to call the healthcare provider and ask questions to clarify the medical certification. Just keep in mind that you cannot ask medical or condition related questions. But like I said, you can ask for more specifics and clarification on anything they've written on that form. I also recommend that the manager of the employee is not the person to do this. Again, this needs to be an HR representative or a manager in the company that does not have direct hiring or firing decision-making abilities over this employee, because sometimes physicians give us more information than we want, even though we only ask a direct question. Sometimes they're talkers, they go off, they say things they shouldn't. If you didn't ask about it, it's not necessarily on your liability that you know about it, but we want to make sure that we are keeping that gap between potential retaliation and non-potential retaliation very wide. And we do that by making sure that there is a removed party clarifying and getting more information on that medical certification. And finally, remember that you can always request a recertification if the deviation is significant enough to warrant a new approval or decision letter. So like I said, if you have someone who's going out for physical therapy and their physical therapy is supposed to be every Wednesday at 2 o'clock and they're claiming FMLA time every Friday and Monday, then that is a definite deviation, and you want to recertify, ask them to have their physician or their healthcare provider fill out the form again, provide us some updates, because maybe they moved it to 2 physical therapy sessions a week and the employee didn't notify you, which is totally possible, and it's happened multiple times in my experience. So you always want to use recertification as something that you can use as a tool in order to make sure that you have an updated approval and decision letter for that time. I always recommend using the recertification option sparingly, because you also don't want recertification to come off again as retaliation. There's a fine line between doing your due diligence and retaliating against an employee, and that is the line we are constantly walking to make sure that we are proactive, but at the same time, we are not hurting the employee or inconveniencing the employee in any way. So we also want to make sure, if you are going to recertify any type of certification, if you want a blanket policy in your company for every intermittent leave you recertify every 6 months across the board, feel free to do that, because that's treating everybody the same. It's a basic recertification process, and then the rest you can treat as a case-by-case basis. But be sure to have very good reasoning as to why you are going to recertify a leave. There has to be some significant deviation from what was approved in order to justify it and protect your organization from a retaliation claim. All right, so those are the top 10 mistakes employers make with FMLA, and a few tips and tricks to avoid those mistakes or be very proactive against those mistakes. So if you did not get the chance, feel free to take a second right now and ask a question via the question box. Just as a reminder, this presentation was recorded and will be available to watch again. To do that, you can visit www.payentry.com and hover your mouse over the webinars tab at the top and click on webinar recordings. The most recent recordings will be on the top, and these are usually posted within 24 hours of the live webinar. You will also be emailed a copy of the webinar recording tomorrow afternoon. There's also going to be a survey that follows this webinar, so feel free to leave your feedback and let us know if you have suggestions for any topics you want to see on our webinar schedule in 2021. We love getting topic ideas from you guys, because we really want to know what you want to hear, what you want us to talk about, what you want more information on. So feel free to send us those suggestions. We love hearing from you guys. All right, let's see what questions we have. Can I receive a copy of the presentation via email? Yes, I apologize. I was supposed to talk about that. I was not able to get it uploaded for whatever reason. I will go ahead and send it all out via email to everyone at the conclusion of this presentation, so you have a copy of the slides. The next question is, can't the employer insist the employee complete the FMLA paperwork? Not necessarily. So FMLA is an optional entitlement, so they don't have to use FMLA if they don't want to. Now, if they are going to take a leave of absence and they are requesting a leave of absence, you can require them use their FMLA time, rather than just taking like a personal leave of absence or taking it under a state law. Most state leaves do run concurrently with FMLA anyway, so both of them would be used up if you're concerned about employees taking too much time off. But once you give them the option to take FMLA time, if they don't want to take a leave of absence, they don't have to. So that is their option. A question about furlough hours. I believe if you're asking about furlough hours, I'm not sure if you're talking about the entitlement. If you're talking about the entitlement, FMLA entitlement question, then any hours that would not be scheduled to work, usually when they're on furlough, they're not scheduled to work, so you would not have to include that in your calculation. All right. What designated agency can we contact with questions regarding FMLA if we are unsure about its use? That is a really good question. I don't know off the top of my head. Let me look into it and I will respond and let you know. I feel like I should know that, but I'm blanking on it. So let me look into it and make sure that I give you the correct information on who is the designated agency for FMLA. All right, we got a long one here. Hold on one second. In determining eligibility with a variable work schedule, what if the employee does not have a set schedule? For example, there's seasonal work and a start time is given from day to day, and weather could lead to unexpected time off. How do we calculate this? Well, remember too, if you have seasonal workers that only work for you for a period of time, they're probably not going to qualify for FMLA because they're more than likely they're not going to meet that 1,250 hours over the last 12 months. So I would keep that in mind as well. It also depends on how you process seasonal workers. I know a lot of the times organizations have seasonal workers, and once the season is over, they're no longer employees, and you have to be employed for 12 months prior to the start of your leave. So again, they probably would not qualify in that specific circumstance that you provided. However, if they are seasonal workers and they just have an increase of hours seasonally, just make sure that you are calculating that average hours scheduled over the last 12 months. So you will have to go back and look at what their scheduled hours were and calculate that average for that FMLA request. How does FMLA look for government contracts when their employer who was awarded a piece of the contract has less than 50 employees, or if they have at least 50 employees, but they are spread out across the US? So in order for you to be eligible to offer FMLA, you do have to have 50 or more employees, and they do have to be within a 75-mile radius of each other. So if you don't meet that qualification, then on a federal level, regardless of government contract or not, you do not have to offer FMLA at that point. That is the requirement across the board. Can an employer force an employee to take PTO concurrently with FMLA? Yes, you can. I do recommend that you have it in your FMLA policy in your handbook that you do require employees to take PTO time or expire their PTO time with FMLA. Also, what I would say to take into consideration is if you have a short-term disability plan or a short-term disability policy that you sponsor for your employees, usually what employers will do is they will require the employee to take the first 5 days or 5 to 6 days off, or excuse me, the first 5 to 6 days in PTO, so that way there's no lapse in payment. So they'll get 5 to 6 days of PTO, and then usually the short-term disability will kick in shortly after that, because you cannot fulfill the short-term disability requirements until after they've gone on leave. So if you do sponsor short-term disability and they would be eligible for that, they would not be able to double dip. So once they apply for short-term disability and once they start getting payments of short-term disability, you cannot pay them PTO at the same time, because that will get both them and you in trouble. So I would just kind of keep that in mind. If you do have a state-sponsored disability or a short-term disability plan, you don't want the employee to double dip. So just keep that in mind if you're developing that type of policy for your organization. If they don't take FMLA and their attendance is not good, what do we do about that? So if an employee is missing a lot of time off of work, and let's say they tell you it's about a medical reason, and you provide them the FMLA information and they don't take it, 2 things I would suggest is I would at least have 1 to 2 documented incidences where you follow up with that employee and say, hey, let's say her name is Sally. Hey, Sally, just wanted to follow up on the FMLA documents I sent over to you on XYZ date. Do you have any questions for me? Let me know if you need any assistance in filling out this paperwork. This shows that you did due diligence to follow up with that employee to make sure that they didn't have any questions on FMLA and that they had the information that they needed. This documentation helps you in case, like you said in your question, if their attendance isn't good, you're obviously going to process them through your regular process of corrective actions. So let's say they get to a final corrective action, you're about to terminate them for attendance, and now they're going to say, well, I was supposed to be protected under FMLA. Now you have some documents at least to come back with and say, we followed up with you, we provided you the information, you chose not to take the time off and protect that time. You can't force an employee to take FMLA. It is an entitlement that they have, but it is their right to choose to use it or not. So as long as she's not in the middle of that process, or even starting that process when you go to terminate, there's less liability. I mean, obviously any termination is going to have liability, but there would be less in that instance. The one thing I will say is that if she gets to a final written and she's about to be terminated for attendance, and all of a sudden she starts that FMLA process, I would recommend waiting to terminate until that 15 days have passed if she turns in her certification. Because like I said, you can retroact dates that would be protected based on the reason for the leave, and that could completely negate your termination decision. So I would just be very careful in that instance if the employee all of a sudden at the end decides to apply for FMLA and utilize the information that you provided. I hope that helped. I know it's a little bit complicated, but I hope that helped. Are there any websites for good resources to help with determining FMLA and or FMLA policies? I know SHRM is a good one. If you have a SHRM membership, I know some of their Some of their policies they provide for free. Some of them they do not, but they have a really good kind of baseline policy. I know I need to look up the agency that controls FMLA. I feel like I know what it is, but I don't want to misspeak. In the email that I send out with the slides that I'm going to send out to you guys, because I did have that technical difficulty, I will also include on there what is the FMLA governing agency, and then I will also provide an FMLA like FAQ website that could help you draft policies and figure out kind of what your qualifications are. So I'll include that in the email as well, because I'm getting quite a few questions about those resources. I'll make sure I add those resources in for you. All right. Next question is, was FMLA paperwork required to be completed for the FFCRA under EFMLA? No. So FFCRA is completely different than FMLA. FFCRA is the 80 hours that was required in 2020 and optional in 2021 by the federal government in order to subsidize time off for COVID and COVID-related illness or quarantine. So FMLA has really nothing to do with that directly. However, if they exhaust their 80 hours and let's say they're hospitalized with COVID and they are eligible for FMLA, at that point you would want to provide them FMLA information if they do have to stay out because they may be eligible for a leave of absence if they have to be hospitalized for an extended period of time due to COVID. However, you do not need the FMLA paperwork for FFCRA. FFCRA is really treated more just like a paid sick leave. It's not really related to FMLA in the structural sense. All right, well, I think that was all the questions. So if you guys do have any other questions or anything like that, feel free to reach out to me. My contact information is at the bottom of this slide. Next week, Kathy is going to be talking about everything you need to know about the Employee Retention Tax Credit, or ERTC. We've gotten a lot of questions about it, so Kathy is going to do an entire webinar on it and give you all the information that you need. So if you are interested, don't forget to register on our website for next week's webinar. And we will be very excited to see you guys there and come with lots of great questions. Thanks so much for your time today, guys. You have a great rest of your week.